Hi, everybody. Thanks for... Oh, we're all in the lobby. Hi, everybody. Thanks for joining us. We're just waiting for a few other people to join, and then we'll get started. So I hope everybody's doing well this morning. Shut my door. Okay, so we'll get started. Just make sure that everybody's coming in. Right, so I'm going to share my screen. Good morning, everybody. Thank you for joining us this morning. My name's Alison Smith. I am CEO and lead consultant at Roots Human Resources, and I'm joined today by my colleague Jimmy Van Santen, who many of you may know. He is the service manager for our Comply service, which is our sort of HR advice line. So we're very pleased to be with you this morning to go through and just deliver an update for you this September on the Employment Rights Bill. So we'll take you through the sort of the changes that are coming up, the changes that are planned within the Employment Rights Bill. We'll talk a little bit about what's happening with the bill at the moment, where it is in Parliament, and then there is a roadmap, a sort of an implementation map that the government have produced about sort of likely timings for some of these changes, when they'll come into place over the next likely 2 years. So we'll run through what that looks like and some of the changes that are proposed within the bill as we go through that. So as we sort of get started, let's have a look at the Employment Rights Bill itself. So the bill is an ambitious piece of legislation. It's going to be perhaps the largest changes to employment law over the sort of the past 20 to 30 years. Where we're at now, it's been a bit of a sort of a strange few weeks almost for the bill. So obviously we had the departure of Angela Rayner from the cabinet, and there was some immediate concern that this might impact on the bill. And I think even a lot of the unions came out publicly, sort of, hoping, defending, expressing concern to the government, wanting the bill to still continue, even though she departed from the sort of deputy PM role. But the Employment Rights Bill and some of the information that's contained within it was a manifesto promise. So I think it was always unlikely that it was going to do anything other than progress in its current form. So where is it now? Well, final readings have taken place, and what we're essentially waiting for now is royal assent. It's likely that that royal assent is going to be sort of given to the bill probably no earlier than mid-October, because we're in party conference season now, and party conferences will continue until the middle of October. So we're looking at mid-October at the earliest for the bill to get royal assent. Once it's got royal assent, it will essentially become the Employment Rights Act 2025. But as we've said on the slide, some elements of the bill in its current format will be subject to secondary legislation and consultation. So things could potentially be subject to change, either through the outcomes of consultation or potentially through delays. So we'll have a look through what the intention is for implementation through what the government's produced as the Employment Rights Bill roadmap. But as I say, we caveat that by saying that consultation is going to happen on many of these things, and we've got a roadmap, but that could potentially be subject to delays, whether those are intentional or not. So the roadmap that's been produced is essentially running from this autumn through to sort of autumn of 2027 at the moment. There's things that will come into play in April of 2026. That will include things like changes around redundancies, some changes around family leave and pay, establishment of a Fair Work Agency. We then see a bit of a gap, and some of on the roadmap itself, then we've got some changes coming in October of 2026, which includes ban on fire and rehire and a launch of the Fair Pay Agreement negotiating body for adult social care. And then 2027, we are looking at some changes in terms of things like gender pay gap and menopause action plan reporting and making those mandatory, enhanced rights for pregnant workers, protections against zero-hour contract abuse, and day one unfair dismissal rights. So many of these consultations, particularly around things like protections against zero-hour contract abuse and day one unfair dismissal rights, we're going to see consultations starting for those. The roadmap itself sets out that some elements of consultation will start this autumn, some in winter, as we're not likely to get royal consent until mid October, then it's probably more likely to be into November, December at the earliest before consultation starts. And there's quite a few of the measures that they're saying they're going to start consultation on in autumn and winter. And some of these are quite significant changes that are being proposed. So consultation around fire and rehire, consultation around what's been termed ending the exploitative use of 0 hours contracts, as well as things like changes to entitlements to bereavement leave, collective redundancy, flexible working, etc. So there's quite a bit of consultation that's due to start once the bill becomes an act itself. So if these are topics that are of genuine concerns to organisations, to yourselves, then it's possible that you could become involved and obviously have your say in terms of what's being proposed and consulted on through the Employment Rights Bill via these consultations. And the government will normally advertise, publicise consultations on their website and allow you to participate online in most occasions too. So we're going to see some of these consultations start, and as I say, we'll know once consultation on these matters concludes whether or not there are going to be any changes on what's currently proposed within the bill itself. What we know in terms of changes at the moment is that there are changes coming in April of 2026. And what these will includes changes around some day one rights. So the government is proposing to remove minimum continuous employment requirements. So these things become a day one right for paternity leave, unpaid parental leave, and bereavement leave. So there'll be no maximum or minimum, continuous employment needed for an employee to become eligible to paternity leave, unpaid parental leave, and bereavement leave, and the pay where it's associated with those. Obviously, the parental leave here is unpaid. So that will change with effect from April 2026. In addition, we already know that there are changes that are coming to statutory sick pay. So what's going to happen is the current waiting days rule, so where statutory sick pay is paid after the 3rd day of illness, is going to be abolished. So this means that employees will be able to claim statutory sick pay from the very first day that they're sick. So there'll be no more waiting days. They're also removing what's currently known as the lower earnings limit. So this is a requirement that is currently in place for employees to earn a minimum amount to be able to qualify for statutory sick pay. So that minimum amount is going to be removed, and it means that there's going to be millions, probably more workers who are going to become eligible to statutory sick pay, you know, including those who might be on low wages, part-time contracts with irregular hours. And there's also going to be a new calculation for statutory sick pay for lower earners. So previously, people who earned below the lower earnings limit, sorry, not previously, this is going to be for those people who previously earned below the lower earnings limit, so those lower paid staff, their SSP entitlement, their entitlement to statutory sick pay, will either be 80% of their normal weekly earnings or the set rate of statutory sick pay. So it'll be the lower of those two. So either 80% of their normal weekly earnings or the current set rate for statutory sick pay. Now, statutory sick pay at the moment is, I think it's £118.75 per week. That will increase from April 2026. So key things: statutory sick pay entitlement from the first day of sickness, no minimum weekly earnings to be eligible, and a new calculation for those who are currently on lower wages. And we know that that's coming into play in April. What's also coming into play is some changes to whistleblowing. Now, the measures aren't specifically specified in the roadmap, but what we do know is that reports of sexual harassment will become a qualifying or a protected disclosure under the bill. The House of Lords themselves proposed several other measures, but these were rejected by the government. So what we do know, though, is that from April of 2026, claims of sexual harassment can be a protected disclosure under whistleblowing law. There are some other changes that are coming into play in April 2026. So they are simplifying trade union recognition processes, introducing sort of electronic and workplace balloting. Obviously, that is only going to apply to potentially larger organisations or those where their requests are met to request trade union recognition within the workplace. There's also some changes to the collective redundancy protective award, and they're going to start to establish the Fair Work Agency. We're kind of yet to see real detail of what that agency is going to look like and what its role will be, particularly sitting alongside bodies that already exist, such as ACAS. But we will start to see what that agency is going to look like from April of 2026. From there, as I say, while periods of consultation around some of those areas, such as fire and rehire and the exploitative use of 0 hours contracts, will continue, it's likely that further changes will then come into place in autumn, likely October 2026. And what's on the roadmap for autumn 2026 is what we're going to go through next. And I'm going to hand over to Jimmy to take you through that particular section.
Thanks, Alison. So we're going to talk about changes that will potentially take place from autumn 2026. And we're going to start with the big one, fire and rehire. And what we mean by that term is where an employer might make changes to someone's terms and conditions, you then go into consultation, you don't find agreement, then one of the options available at the moment is to essentially dismiss the employee on the existing terms and conditions and then rehire them technically on the new terms and conditions. And what happens in practice is that, technically speaking, you have dismissed the employee, and so they can make an unfair dismissal claim if they have 2 or more years employment. So anything before that, employees cannot make a claim at all. And so this can be exploited, of course, quite a bit, where employers might want to change hours of work or benefits that might be available to them. Now, what the government is proposing is that that practice is going to be banned completely, or it's going to make it very difficult. And so what they first going to do is say, okay, well, when fire and rehire takes place, we're going to make it an automatic unfair dismissal matter. And what that means is that you don't need that minimum 2 years service before you can make a claim. Any employee, no matter what their length of service is, can make a claim of unfair dismissal if the reason for that dismissal was the fire and rehire or the changing of terms and conditions that they didn't agree to. And so they can then make a claim and go to a tribunal. And the government is now distinguish between two types of changes, and they're called restricted and non-restricted changes. Restricted changes are where you cannot do it unless the organization is able to evidence that financial hardship is the primary reason for forcing the changes and there were no alternatives available. And that relates to changes for pay, hours of work, or benefits, anything that kind of financially impacts the employee usually. And then we have non-restricted changes, and these are changes that you can make if you need to make them. And these are, for example, changes to location of work, so where people work, because you might have to move office, or there's a new shop opening across the street, or to changes of duties of the role, so changes to the job description. But of course, we all know that job descriptions change over time. We might introduce a new piece of technology, and so we might have to change ways of working. So those two changes can still be made, and you don't have to evidence financial hardship, but of course, the change should still be reasonable. And ideally, you still find agreement with the employee for those changes. Now, the other thing to kind of keep in mind is that the government has also introduced as part of the ban on fire and rehire that employees cannot change the workforce by replacing them with non-employees. So if, for example, you think, okay, well, look, we are running this particular section here, it doesn't really work with employees, we're better off financially speaking to have self-employed people, you can't do that going forward, and it will be again automatic unfair dismissal matter for the employees if they were dismissed for that reason. So that's kind of the ban on fire and rehire. It's quite a big one because I think it's going to make things a lot more difficult to make changes in the organization, and especially for obviously charities and other organizations that rely on funding streams and maybe perhaps even restricted funding streams. It can become a real issue where you might have to make changes because there's a reduction in a particular funding, but it doesn't actually present an overall financial hardship for the rest of the organization. So it's going to be a very interesting impact on how this is going to obviously affect those organizations that rely on those different income streams, because I think it's going to make things very, very difficult for you. But it's still under consultation, as I understand. So it may well be that things still change in between now and October 2026. But for now, this is the plan of the government to make it very difficult to go through the fire and rehire. Next, so harassment. So if you may recall, last October in 2024, the government introduced additional kind of duties and responsibilities on employers to prevent sexual harassment to happen in the workplace. Of course, it was already a duty on the employer to prevent that, but they've increased those duties and responsibilities and put some more kind of measures in place that where employees can be taken to a tribunal and be punished for that if they don't have the right measures in place on sexual harassment and prevention of sexual harassment. Now, this is going to be extended to third-party harassment. So that's harassment that might come not from an employee or from a trustee, but comes from a third party, another organization, perhaps a partner organization. It might be a service user, it might be a client, it might be a supplier who has harassed an employee. And you're going to have to be able to demonstrate how you put measures in place to prevent that as much as possible. And also, there's going to be more onus about how you would handle such a complaint if it does happen, because it sometimes will happen. People will do stupid things. And so then it comes down to, do you have processes in place on how you're going to manage that issue when it actually transpires in your organization? And what I can foresee, for example, as one of the things that might happen as a result of this is that organizations are going to ask for each other's harassment policies and trying to work out, if I'm going to work with you, what have you put in place to ensure that harassment doesn't take place in your organization. And so already you see that, for example, with funders ask for whistleblowing policies or EDI policies. I can see that very much becoming a thing where they might start asking for harassment policies, just so that you understand that the people that you're going to work with have been also trained and informed that this kind of behavior is not appropriate in the workplace. There'll also be an additional step to make sure that you take all reasonable steps to prevent sexual harassment. Now, again, that already is somewhat in place, but what the additional or reasonable steps mean is just that everything you can possibly do within the resources you have available to ensure that staff are trained, are told that this is not okay, to have measures again in place for people to go to actually complain about someone else who may have committed an act of sexual harassment, so that again, and also that there are protections in place for those individuals to make those claims, grievances, or even soon to be whistleblowing concerns in the safety of you as an employer. Part of this as well is that the government is proposing to make changes to non-disclosure agreements. So at the moment, what you can do is if, for example, there's an issue of harassment or discrimination, sometimes what happens is that employees will say, well, look, why don't we give you a settlement agreement where we pay a certain amount of money and you promise not to A, take us to a tribunal for that, but two, also not to tell anyone else about it, because often the reasons for a settlement agreement kind of is captured in a non-disclosure agreement. That going forward from autumn 2026 is most likely no longer possible because the government is proposing to invalidate that completely. So even if there's a claim for non-disclosure about the discrimination claim, that will be completely invalidated, and employees can still make disclosures to other parties about the discrimination or the harassment that they face within your organization, despite perhaps a settlement agreement being in place to settle the claim for a tribunal. Very weirdly, and I think it's an oversight from the government, but they have ensured that claims of failure to make reasonable adjustments are not covered by that provision, so that can still be covered by an NDA if you decide to do so. So then next we have the tribunal time limitation. Now this is a bit of a strange one, but at the moment you have, or an employee has 3 months time to make a claim in a tribunal after the alleged instance. So if they've, for example, been dismissed and they want to claim unfair dismissal, they have essentially 3 months the time to go and make an application to the tribunal. Now that can be extended by a month if they go to ACAS, and you always have to go to ACAS first anyway to get a certificate to make an application to a tribunal. But usually what ACAS will try to do is to get you to do some early reconciliation. If the employee opts in for that, they get an extra month to make a claim to a tribunal. So essentially they have 4 months in that case to submit their claim to the tribunal. Now, there are already some limited claims that carry a 6-month time limitation, such as the failure to consult during a TUPE transfer, but they're very, very limited, those claims. The vast majority is actually limited to 3 months. What the government is now proposing is that from, again, autumn 2026, that time limitation is moved from 3 months to 6 months for all claims. So in other words, employees, if they've been dismissed, if they face discrimination in the workplace, anything that they can make a claim for can now be made within a 6-month period. I'm not entirely sure why the government has done this, because I think it creates a lot more uncertainty for employers for a much longer period. And also employees potentially are going to sit much longer on these potential claims before they submit it. But I suppose it gives people more time to prepare for a case where, for example, the case that they want to bring to an employment tribunal is quite complex, and they want to make sure they've got the right legal advice before doing so. So it's going to go to 6 months. Really, all that means for employers, there's not really much you can change in policies or contracts because it sits outside of that. It just creates that additional time of uncertainty to whether someone is taken to a tribunal or not. Now, the other change that you tend to, that we think might happen in 2026 or autumn 2026 is something about tipping laws. Again, for most organizations in that sector, that probably is not an issue, but if you run a cafe or some kind of restaurant where people can tip, then of course that is something you need to be aware of. We don't know the full extent of what those tipping laws might include, but it would likely be that tips have to go to the employee rather than to the organization, and that should be probably covers all 100% of the tips. 2027, we're going to see some big changes, or at least there's some big changes proposed. And the biggest one that we probably all seen is the day one unfair dismissal claim. Now, currently, employees need 24 months or 2 years of continuous employment with the same employer to make a claim of unfair dismissal. And although there are some automatic unfair dismissal claims, such as, for example, discrimination, or if you been dismissed for committing a protected act like whistleblowing, or you were involved in trade union activities, then you can make a claim pretty much from day one, because we class those as automatic unfair dismissal claims where you don't need that minimum level of service. Now, in 2027, the government has said that actually what they want to do is to make sure that all employees, regardless of the claim, can make a claim from day one. And so unfair dismissal claims can be made from day one of their employment if they feel they were dismissed unfairly. Now, it should be noted that the government is currently starting consultation in the next few weeks about this. And it's very likely that there's going to be some watered down version of this, because a lot of organizations across the sectors have raised, rightly so, concerns about this proposal. Because, for example, what would happen if you have an employee who lied on their resume, was very good in their interview, and then come into the workplace and they turn out to be not suited for that role? All of a sudden, it's going to be a lot more difficult to dismiss them because there is a legal claim hanging over you. Now, if a day one right were to come in play, it's very likely the government would introduce some kind of statutory probation period. So at the moment, probation is contractual. It's up to you to decide how long that probation period is for, what kind of process you would run, how you would determine whether someone needs to be dismissed or not, where if a day one right were to come in play, the government would likely make that statutory. And so there'd be some kind of code of practice most likely around how you handle probation periods, and also how you would deal with underperformance during that period, and potential even dismissal if that's required as part of the probation. But for now, we know it's going to go to consultation, and it's, as I said, it could very well be, once organizations start getting involved, that this becomes not a day one right, but maybe a 6-month or a 12-month right, something similar to pre-2010. Next, we have bereavement leave. So currently, there are 2 weeks of parental bereavement leave available to working parents who lost a child after 24 weeks of pregnancy and up to the 18th year of the child. So if you lose a child within that period, then you are entitled to 2 weeks of parental bereavement leave and pay as well if you're eligible for that. And that leave, if obviously there's still a pregnancy available, is usually available to you as well, in addition to maternity and paternity leave in play. Now, what the government's proposing is that 2-week parental bereavement leave be extended to those parents who lose a child also before the 24 weeks of pregnancy. And so it would most likely cover the whole pregnancy. And so that obviously is very important, because no matter when you lose a child within the pregnancy, that's obviously a very difficult period for parents. And so having those 2 weeks available is going to be vital. And I'm actually very glad to see that being introduced. And in addition to that, the government is also introducing potentially a 1 week unpaid bereavement leave for all cases. And when we say all cases, it's most likely going to be limited to direct families. So parents, children, or it's already covered by the parental bereavement leave, and siblings. It will likely be unpaid. And of course, organizations then have the option to allow for paid bereavement leave in addition to that if they want to do so. Already, a lot of organizations that we work with, we know they kind of offer 3 to 5 paid days of bereavement leave, but it's completely at the discretion of the employer at the moment to decide to actually offer that. But from 2027 onwards, it's very likely to become a statutory right of 1 week unpaid leave. And then again, in addition to that, employees can offer paid leave or additional leave if they decide to do so. Next, we have 0-hour contracts. Now, there's been a lot of talk about 0-hour contracts, and for a while, the government, especially in the initial stages of the Employment Rights Bill, were very keen on banning 0-hour contracts completely. But they've kind of watered that down quite a bit. And it's no longer talking about bans, but it's more about restricting 0-hour contracts. And one way the government is proposing to do that is by saying that employers will be expected to offer guaranteed hours based on the hours that the employee is working on a regular basis over a particular reference period. And that's going to be likely something like 12 weeks, where we need to look at the average number of hours worked over each week, and then that will be offered to the employee as a minimum guaranteed hours contract. Now, what the government has said is because they have recognized that people do like to be on zero-hour contracts sometimes because it can create that flexibility. It allows for people to work in different places if they decide to do so. They can fit their kind of work life around their private life. And so because they recognize that people do sometimes appreciate zero-hour contracts, they have suggested that there will be an option to refuse those guaranteed hours. So if an employer offers guaranteed hours, which they'll be most likely required to do by the new piece of legislation, the employer would have the option to refuse those guaranteed hours and remain on the zero-hour contract. Now, at the moment, it's quite unclear whether you need to constantly renew the offer of guaranteed hours or if that's a one-off. But for now, we know that it's going to be a requirement to offer those hours and an option for the employee to refuse those hours. The other thing to keep in mind is that there will be some kind of compensation for last-minute cancellation of changes to agreed shifts. So if an employer has agreed to work a particular shift and then you cancel it because perhaps the event that they were going to work at is no longer going ahead or kind of reduced need, then there will be likely some kind of compensation that you would have to offer to the employee, most likely some kind of percentage of the daily rate or the hourly rate that they would have had received if they had worked that shift. Again, it's not entirely clear what that looks like in practice, but I'm sure that will become more clear in the coming months. But there will likely be some level of compensation available to those employees. Now, again, consultation is expected on this in the coming months. And one of the things that the government will consult on is, for example, the length of any reference period, because, of course, 12 weeks can be problematic if you have seasonal workers where, I don't know, during the Christmas period, or maybe you deliver child clubs during the summer holidays, where people on zero-hour contracts doing a lot more hours on average than the rest of the year, and yet those hours are going to be taken into account on a reference period, which of course can create really weird results that are disproportionate for what you need in that particular role. So we're going to see some more consultation coming up in the next few months about zero-hour contracts, and also we're probably going to see some more clarity about what they're going to mean by low hours contracts, because of course there's always been this talk about zero-hour contracts potentially moving away to a low-hours contract, but what does that actually mean? Does that mean we could offer 1 hour contracts, or is there going to be a minimum amount of hours that we would have to offer? So again, we're going to see that hopefully in the coming months with the government clearing it up for us. Next, then, we have flexible working. Now, flexible working has seen some changes over the last 11 years or so. So back in 2014, we saw some significant changes. Then last year, we saw some more changes. And just to kind of recap on that, is what was introduced last year is that employees used to need to have 26 weeks continuous service before they can make a request. It became a day one right last year. Also, instead of 1 request per year, they're now entitled to make 2 requests. Employees must consult the employee, especially where you're potentially deciding to refuse the request or not completely agree with the request. You must now consult with the employee about that and kind of work out how things can be introduced. There's also no longer a requirement on employees to explain how the new flexible working structure would work for the rest of the team or the organization. That's now the onus is completely on the employer, no longer on the employee. And you must complete the whole process in 2 months, which used to be 3 months. And if you offer an appeal, which is not a statutory requirement, but most employers that at least we work with do offer an appeal in these processes, then that appeal must still be completed within the 2 months as well. So it sounds like a lot of time, but it flies very quickly. Now, what they have said was that in 2027, they want to strengthen these flexible working rights further. And they've kind of announced that they want to do flexible working by default. Now, again, they've not been overly clear what they mean by that, but it's very likely that they're going to make it more difficult to refuse a request if an employee wants to work flexibly. One of the things they have said, for example, is that employees can only refuse a request if it's reasonable to do so, and then you must be able to explain why it was reasonable to refuse that request. It is something that we already recommend our clients anyway that you do. You know, it's always best to be clear and open and transparent about why you might not be able to accommodate a flexible working request, because then the employee can see why it's not possible. But that's going to become a lot more important once this new strengthening of the legislation is going to come into place in 2027. And then that's it, 2027. There will potentially see more right to pregnant workers in 2027. And again, we are trying to see what that means. They've not really given us any clarification. But again, we'll find out in the next few months what the additional rights would be. It may well be that they change the way entitlements work further than what's already going to happen next year. Other than that, what I've got left to say, of course, if you've got any questions, please put in the Q&A. I don't know if there's already questions in the chat as well that we can have a look at. The other thing to say is that we are planning to run another webinar sometime in 2026, early 2026, just to kind of go over the more details of what's going to be introduced in April 2026, as well as kind of the statutory changes that we see every year anyway, in terms of the new statutory payments for maternity pay and sick pay. And also, if we then know more by then about the Employment Rights Bill, of course, we can also update you within that. And in the meantime, do have a look on our website. We do update our blogs. We do update people through our newsletter with the changes. So when they do come in, then of course, they'll be available there as well. So yeah, Alison, I don't know.
Loads of free resources on the website as well.
Yes.
There's been a few questions that have come up in chat, which I've kind of answered as we've been going through, but I know not everybody will have access to chat. So I just thought I'd quickly cover those off. If anybody's got any other questions, please do pop them in the chat. So somebody asked about contractual sick pay, if they offered that, and that is inclusive of SSP. Will the changes to SSP affect them? The answer to that is going to be no and yes. During the period of contractual sick pay, then obviously if it's inclusive of SSP, there's no change to the level of payment that the employee would receive. But if the employee exhausts their entitlement to contractual sick pay, obviously exhausts their entitlement to contractual sick pay, their entitlement to statutory sick pay is likely to still continue, because that's up to a maximum of 28 weeks. So obviously in that situation, where they're only entitled to statutory sick pay, the new rules, if you like, around entitlement and lower earnings limits, etc., will apply. We got asked in terms of sexual harassment, is the duty not already in place? There were some duties that came into place in October of last year, 2024. There's now further duties that come into play in this October, so 2025. And also asked in terms of whether there are any changes coming in place this autumn. So the immediate changes that are going to come into place once the bill receives royal assent are focused around trade unions and trade union activity. We've not gone into detail on those in this session, because obviously we find that most small social sector employers don't actually recognise trade unions, but there's more information that's available on that through the government roadmap if that is something that you're interested in. But as we said at the start of the session, what is going to happen this autumn winter is consultation will start on some of those larger proposed changes, you know, as Jimmy's touched on, around things like day one fire and rehire, around day one unfair dismissal. So they will 0 hours contracts, they'll all start this sort of autumn. So there is another question that's in there. Is there any indication that the fair pay agreement for adult social care would be met by increased statutory funding? I don't know is the answer to that. I don't know if there's any indication, and I don't know if it's likely that there would be any statutory funding or increased statutory funding for that. And I'm not sure when you may get information on that, but yeah. Don't know is the answer to that one at the moment.
Great.
I don't think there's any other questions. The union recognition lowering percentage threshold could have a massive impact for the charity sector. I know you've said info on the website, but it would be amazing to have a future session on this, please. We can certainly look at that, and whether that's of interest, then we can certainly look at doing something in the future. And if there's any other topics that you would find helpful through our webinars, then please do just let us know. You can drop us an email on info, you can pop it in the chat now. We are always very keen, you know, information from yourselves in the sector as to any topics that would be really helpful for you through any of our free resources and our webinars. So if there is anything else, then please do let us know. But yeah, we will certainly take that away and look at that. But as Jimmy said, we'll definitely be doing another webinar in early 2026, just to start getting prepared for any of those changes that are coming from April, and any updates that we then have in terms of what will likely be the Employment Rights Act at that point.
Yep.
Okay, doesn't look like we've got any other questions at this point, so we'll just say thank you. Again, thank you for your kind comments in the chat as well, and we'll send out the slides from the session, and the copy of the recording of the webinar will also be on our website fairly soon, so you'll be able to access it and re-watch it. So thank you everybody for attending. Thank you very much, and we look forward to seeing you again at our next webinar. Thanks everybody. Bye.
Take care.